right, well, welcome. This is our first community workshop that we've had in a very long time. So I think that it was February of, well, we may have had the March of 2020, but we want to welcome everybody back. And thank you for joining us today. And so the first thing I want to ask is that for those of you who are on Zoom, if you would please mute your microphones on your computers. And also, if you have any questions, please enter them in the chat section of the Zoom, and we will address all those questions at the end. So at this time, I would like to introduce Andrea Goley, and she has been an attorney in Amarillo for 17 years. She has been an attorney with AISD in the past and currently is representing AISD, but not an employee of AISD. So she's a graduate of Oklahoma University Law and Nebraska undergraduate. So she specializes in areas of education law. And so we're going to hand it off to Andrea and we'll get started. Thank you.
It's great to be here with you this evening. As she said, my name is Andrea Goley, and I'm with the Walsh Gallegos Law Firm. I know we're newer to Amarillo, but the firm has been around for many, many years, and we have several locations throughout Texas and in New Mexico, and we have about 70 school lawyers. So our firm does exclusively school law. Although there's not a specialization per se from the bar in school law, it is an area that most people who practice in, it's a large part of their practice because education law has become more and more specialized, so to speak, where it's something you really have to, you don't dabble in it, let's put it that way. Most people don't dabble in education law. It's pretty complicated, and that's especially true for special education law. In fact, there are a lot of school lawyers who won't touch special education law because it is so intricate and there are so many rules you have to know. Personally, it has always been my favorite area. In fact, when I started practicing, I really wanted to do only special education law. And this is probably a testament to the panhandle and our nature of getting along and trying to work through problems. There's, knock on wood, not a ton of litigation in the panhandle. There is some, but when we compare ourselves to districts down south, some of those school districts are in litigation nonstop. So we really have a collegial type of approach to education law here in the panhandle, and most of the time we can work through issues with parents. Again, I do represent school districts only, I don't represent parents, but in my experience, we're usually able to work through most issues. I think that's something a lot of school districts pride themselves on, is being able to work with parents. And so a lot of that is a testament to the quality of educators we have in the panhandle. And so I know WT puts a lot of the educators into the panhandle, so thank you for the quality of educators you put out into the area. So all that being said, we have a lot to cover in the next 45 minutes or so. So I wanted to do kind of a high-level overview of some of the disability laws that we run into, and talk through a little bit of child find issues and evaluations, some information on the development of IEPs. And I'm also going to touch on, so I'm going through those issues, some recent guidance or findings, perhaps is a better way to say it, from the feds that they gave to TEA. And so you'll kind of know what to expect that might be coming an issue from TEA down to the school districts. And then also talk about legislative updates, because it is a legislative session still. As of September 13th, we're still doing legislative updates. So we'll see what happens in this third session. Hopefully we won't see a lot of changes to special education, because we have plenty in the regular session. So we'll see what happens. Okay, let's move into just some general understanding of disability law. So a common area of confusion is which laws actually apply to which situations. And so I want to start out kind of a quick overview of Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act. So those are the three big areas that we run into when we're working with students with disabilities. So the best way to think about this, and on this slide I have the Section 504 and the ADA boxes. Those two kind of go hand in hand. They are anti-discrimination laws, they're civil rights laws, and they really are about ensuring that discrimination does not occur against students with disabilities. And so those two are kind of in a league of their own. And then we have the IDEA, which is much more intricate, detailed. There's a lot of rules you have to follow. Section 504 feels very much less structured, although we do have regulations in place, federal regulations. It's just not, there's not the amount of detail you have to follow as there is in the IDEA. So for that reason, I'm going to focus primarily on the IDEA tonight, because there is so much more to compliance. But Section 504 is certainly an important law, and it protects students who have a physical or mental impairment that substantially limits a major life activity, or if they have a record of having such an impairment or are regarded as having such an impairment. And so the intent of 504 is to be broad and more encompassing. And in fact, over the years, school districts and agencies, when it comes to the ADA, were getting a little more restrictive and being less inclusive when they were doing their assessment of who was a disabled person under these laws. And the federal government has come back and said very clearly, we meant for this to be a broad scope. So it shouldn't take a lot of effort to get through that analysis. And so there are a lot of different ways somebody might be protected. I'm going to focus on 504 now, because that's really the part in schools that comes into play the most. And so it can be anything from walking, seeing, hearing, concentrating, learning, or thinking are some examples. The list is not exhaustive. It's actually substantially longer than that. The ones that we run into the most in school districts are concentrating, learning, and thinking. Those are very kind of broad areas. And so a lot of times we have students qualify for special education, or excuse me, Section 504 services because they do have that physical or mental impairment with that substantial limitation. So students who qualify because they have a disability, and this is not something that's short in length, this is something that is longer in duration. So if a student breaks their arm, it's going to be in a cast for a few weeks, that's not what we're talking about. We're talking about a student who perhaps has ADHD and doesn't need special education. Might be a student with epilepsy, a student with peanut allergies, or any kind of substantial allergies, some kind of physical impairment that's basically not going away. That's kind of what we're dealing with more often. So these students receive a 504 plan, and they have a Section 504 committee that's made up of a group of knowledgeable people who know the student, know the disability we're looking at, read evaluations, that kind of thing. And so they decide if the student qualifies under 504, then they create a plan. 504 plans they vary substantially across the state, what they look like. Again, because we don't have this one regimented set of rules you have to follow. If you see an IEP, I'm not talking about the content now, I'm talking about the form. That in special ed, we have what we call IEPs, individualized education plans. When you look at those, you see a pretty similar pattern of what's included, because the state has told us, the feds have told us what has to be included. 504, there are lots of different versions of what 504 plans look like. And so it is a lot more broad. And part of that is because there are so many different types of disabilities that qualify. And so they really need to be individualized. So that's kind of how 504 works in. ADA is truly just an anti-discrimination law. We've got to make sure that people have access to public facilities, public programs, that kind of thing. So that's how those two work. When we get to the IDEA, this is the law that provides a FAPE to students with ages 3 through 21. When I say FAPE, I mean a free appropriate public education. I forgot my disclaimer, is that when you get into education law or education in general, there are a million acronyms. For the longest time when I started practicing, I had like a cheat sheet because there are so many acronyms. So if I say an acronym and I forgot to define it, someone here in person needs to go, that's what that means, because I'll try to remember to tell you before I start saying acronyms. But I think is something you're going to hear a lot about, a free appropriate public education. And that's what we provide for students who have a disability and have a need for special education and related services. And so that's what we're making sure we provide because federal law requires it, so it's state law. We do that through an individualized education plan, which I talked about earlier. That's an IEP. And this was another thing that was confusing to me when I moved into Texas after getting my education law experience in Oklahoma, is we have something we call an ARG here in Texas. You've probably heard about that. It's unique to Texas. I'll never forget, actually, I was watching a training that Jim Walsh was doing, and I don't think I was even licensed yet. I think I hadn't passed the bar. But I was sitting in this meeting at this training, and I was sitting with a client of the firms, and I leaned over. I said, "What is I felt so stupid because like here I am the lawyer and I didn't know what it meant. But I've been practicing all of about 2 minutes, and then she just laughed. This director had been there for years and years, and she said, "That's not APT." I was like, "Oh, okay, thanks." So Texas has a few unique acronyms, ARG being one of them. So once we get into special education law, we really are focused on special design instruction. And this is really the key difference between 504 and the IDEA. I tried to find, when I talk to people who are just learning about these two areas, you think about 504 as having access to a program, and special ed is truly designing that child's education. So it's not just a, how do I help you access classes or extracurriculars or activities. It is, how do we actually make sure that you are getting the education you deserve by modifying things, by providing something extra, whereas 504 is more about access, IDEA is more about extra. Makes sense? And so part of that is specially designed instruction. And so what the law tells us is that is adapting the content, methodology, or delivery of instruction. I think those are the most important 3 words to remember when it comes to special design instruction. It's the content, methodology, or delivery of instruction. If you're doing those things, and if that's what a child needs, then they need to be in IDEA services versus accessing through 504. We have to make sure to address the unique needs of the child that result from their disability, and ensure that they have, again, access to the general curriculum so they can meet the educational standards of the school district. A little more guidance here. This is from Region 20. They did a nice job of putting in easier to understand terms, plain language, I should say, because sometimes special education is not plain language. So they talk about special design instruction being provided through the IEP. And we have goals and objectives that we create for children who need an IEP. So we're going to look at the deficiencies they have, the needs they have, the areas they're struggling in, and create goals and objectives based on their evaluations, where they're at, that kind of thing. And I'm going to get into more detail about that here in a minute. The key to the IEP is individualization and making sure we don't have cookie cutter IEPs. We don't have something that's a one size fits all. If you get into special education, you're going to see every IEP is different because it is so individualized, and that is the key to having a successful IEP. So I'm going to go off track here for a second and focus on something that's really hot on the press. This letter just came down, I want to say a week or 10 days ago, maybe. So TEA is a Texas Education Agency, and they have been trying to basically respond to a corrective action plan that was put out by the federal government. So this is the Office of OSEP, this is the Office of Special Education Programs. And they have been focusing on several different areas. And so one of the key areas they've really been focused on is called Child Find. And if you think about Child Find, the easiest way to remember is just what it sounds like. It's finding students who need special education and related services. And we have to, by law, ensure that school districts have location policies in place to locate, identify, and then evaluate students who might need special education. And actually, there's a Child Find component to 504 as well. And if you walk into pretty much any school in Texas, you're going to see a Child Find poster. It's got green print. It's one that everyone tends to use. If you go into doctor's offices, you're likely to see Child Find information in student handbooks, in school board policies. There's usually a designated area on the website that talks about Child Find. And because it is the start of the process. And so the idea behind Child Find is that it's common that teachers will see a need and they'll say, I think your child needs special education evaluation to parents. But we want to make sure as a state and as school districts, the parents know they can ask for evaluation also. And that's part of the effort behind Child Find, is making sure to educate parents on understanding their right to request an evaluation. School districts don't necessarily have to honor that evaluation, but it's common that they do, because most of the time, if somebody sees a need for special education, whether it's the teacher or the parent or the administrator or whoever it may be, everyone sees kind of the same thing, and they can kind of all agree as to what might be needed for that child. And so Child Find is a very important component of special education. Frankly, it's a very highly litigated area. You'll see a lot of lawsuits over this topic. And just over the last few years, we've had some pretty significant Fifth Circuit decisions addressing Child Find. So it is a hot topic among special ed lawyers. So this letter to OSEP, today we're getting back to TEA on some of the areas they found to be deficient in Texas. And like I said, Child Find is a hot topic, getting the information out to parents about what a FAPE is and what that looks like. Senate Bill 139 was a law passed back in 2019 that requires school districts to put certain information for parents on their website. General information for parents about special education and then dyslexia. These were all the topics that TEA responded to, I think it was back in 2018. And then when OSEP wrote back a couple weeks ago, they said we still need to work on these areas. And so they're still looking for additional improvement. And as I tell my clients, when TEA is told do better on something, it's going to trickle down and the school districts will get more instructions on how to apply to make both TEA and the OSEP or feds satisfied that those issues have been addressed. So I think we'll see additional guidance coming out of TEA on some of these topics. I'm going to talk about dyslexia in more detail here in a minute. The rest of these are we're going to talk about the general topics, but dyslexia is kind of a mystery right now still. I'll explain what I mean by that here in a minute. The other thing that I thought was interesting in this letter, they focused initially at the outset, they talk about masks. And they, obviously the feds are a little frustrated that TEA does not, or excuse me, that the state does not appear to be permitting masks in school. And I would try to give you an update on all the litigation going on, but I can barely keep up with it. Thankfully, I'm not involved in any of it, although our firm is. There's just a ton of litigation going on right now. And so just tell you to stay tuned. If anyone's watching this later on, things have probably changed anyway. So every day there's an update. But what was interesting from a special ed perspective is OSEP basically says to TEA that in their opinion, that the mask mandates or lack of mask mandate, for saying schools can't do that, can impact the provision of a free, appropriate public education in the least restrictive environment for students with disabilities and foster an unsafe learning environment. So what I anticipate will happen is once all of the litigation settles down and the dust is settled and we actually know what the rulings are, TEA will probably come out with new guidance or perhaps the same, I don't know, they'll make it official. And we'll at least know exactly what we're dealing with. And if it doesn't address students with disabilities, I anticipate the federal government will come in and take issue with that. They've done that with several other states. I think 5 states right now are being reviewed for their policies. So stay tuned. We'll see what happens. I think that's something we can anticipate because of what they put in this letter. Okay, so let's move on back into more detail on child find. I mentioned earlier, this is kind of the first step in the process. And so from here on out, I'm only going to focus on special education. So child find has been in the IDEA since the very beginning of the IDEA back in the 70s. And the concept behind it is we need to get to kids sooner rather than later if they need special education or related services. And it's not a let's wait and see if you fail kind of approach. That's exactly what we don't want to do. We want to try to get ahead of it and try to make sure that we find students. And so sometimes it's natural that things, happens where someone may not realize a student has a disability, there is a failure, and that's when it's triggered. The notice is triggered basically. I see that frequently when kids move into a school and maybe they haven't been identified somewhere else, they move in, and then the school says, well, wait a minute, we're not seeing passing grades, and we're seeing something going on here. And they say, let's take a step back and see if this child might need some services. And so, like I said, it's been around for a long time. When this is the 34 CFR section 300.111, that is from the IDEA's regulations. And it tells us that we have to have, as a state, which trickles down to school districts, policies and procedures to make sure that we find students who are residing within the state or within the school district. And that includes students who are homeless, students who are wards of the state, children with disabilities attending private schools, regardless of the severity of their disability. And if they're in need of special education, we have to identify, locate, and evaluate those students. And then we have to make sure there's a practical method developed and implemented to determine which students need services. If you read that carefully, you'll catch that there is kind of a double catch, and that students who reside in a school district might go to a private school in a different district. And so both those districts are responsible for finding that child. Private school students have to be found, but they don't have to be provided a FAPE. Okay, so basically, if parents choose not to enroll their students in public schools, they are waiving their right to a free, appropriate public education. There are certain things districts still have to do, that's kind of getting into the weeds. They do still provide equitable services for private school students, but it's not a FAPE. So the concept of FAPE is what we entitle or guarantee to students who are enrolled in public school. Some important language out of child find confirms that even if a student is advancing from grade to grade, they still might need special education related services. And I think there's been a lot of training on this over the years. If you look back at some of the first litigation back in the 80s, even in the 90s, you would see a lot of cases with schools that say they have straight A's, or they're advancing, or they're in the gifted and talented program. There's no way this child could be in need of special education, and we know that's simply not a reason to decline to evaluate a child. There are some cases where there might be other circumstances that indicate evaluation is not needed, but just based on the fact they're advancing from grade to grade, the law tells us you still have to potentially go evaluate that child. So you could be performing incredibly well in school and still need those services. Sometimes the students who are performing very well might need occupational therapy, physical therapy, speech therapy. Speech only is a very common qualifier under special education. Sometimes those students need counseling or behavior plans. There's a variety of things that children might need, even though they're getting really high grades. Nothing in the Act, the IDEA, requires that children be classified by their disabilities so long as they actually qualify under the law. I'll talk to you about that in a minute. And we've concluded that they need special education services. One thing that is a frequent area of litigation is the dispute over how the child qualifies for special education. So sometimes a parent will think, my child really should qualify as being a student with autism. And the school might say, no, that's really an emotional disturbance. You might have competing evaluations. And really, again, I'm speaking in generalities, but generally speaking, the label, and courts have said this, the label doesn't matter. What matters is how you serve the student and that you actually have a qualifying disability to get you into the student into the program. But still, we see a lot of litigation over, what disability actually qualifies a student. So that's a very common area of dispute. And I would just encourage educators and parents alike to really focus on the needs of the child and not get so hung up on the label, because what really matters is what we're doing day in and day out for that child. So I mentioned earlier, I would talk to you about the dyslexia update, and I wish I could stand here and tell you exactly what the new handbook says, but I haven't seen it yet. And so I actually was kind of putting off finalizing this PowerPoint to the last minute because I was hoping I could get my hands on a copy of what has actually been approved. But one of the hot topics the child find is dyslexia. And so the issue became, traditionally, Texas has served students with dyslexia, for the vast majority of students with dyslexia, through Section 504. And so I mentioned earlier that one of the areas the TEA was told they need to do some work on here in Texas is making sure parents understand their rights when their child's being evaluated as potentially having dyslexia. And so from what I've been able to gather from anecdotal sources is the new handbook is going to say, if you suspect a child has dyslexia, you need to follow the IDEA evaluation process. And the reason that's a big deal is because there are a lot more deadlines, a lot more steps you have to follow under IDEA than 504, which I mentioned earlier. It's a lot more stringent type of requirements. And so from what I understand, I've seen some side-by-side comparisons, but it sounds like the new handbook makes it clear that when you're referring a child for an evaluation for potentially having or qualifying as being a student with dyslexia, then they're going to follow by default the IDEA process. And I'm looking out if you all heard anything contrary, that's my understanding. So I've asked several resources, so stay tuned. Maybe I'll come back and tell you all about that later. But for right now, that's my understanding. And that's what they're trying to, yeah. Well, and that's what the feds have wanted for a while too. And I just put this up here as an example. I'm not going to try to read that really tiny print, but as an example of kind of some of the significant changes in that handbook. When you read the comments from the feds about dyslexia and child find, they would say things like, even though the student wasn't making progress in Section 504, they still don't be told about IDEA and having lots of concerns about getting those full evaluations done. And so this is a document I found that shows comparisons, but this shows that on the left side, the proposed changes on the left is going through and talking about how the student can still have 504 services, but it's more appropriate now for the student process to go through the IDEA. So parents could choose not to receive services under IDEA. And if that's the case, then they'll go back thinking the student can still be served under 504. The bottom line is there's an expectation now that we're going to default toward IDEA, is my understanding. So that's kind of hot off the press. I think that was just last Wednesday. Wednesday was the day they had a meeting, if I remember correctly. I had a meeting with a bunch of directors on Thursday, and nobody had a copy yet. So, but that was what the folks who watched told me. Okay, so let's move on to, we talked about child find, how we have to have this process in place. Let's talk about eligibility and how a student actually qualifies and what some of the evaluation processes are. So there's a two-part test for determining if a child is eligible for special education and related services. First is, of course, they have to have a disability. And then the second part is, as a result of that disability, they must need special education and related services to benefit from their education. And a very common misunderstanding, a very common way that schools and parents get crossways is parents will walk in and say, my doctor has diagnosed my child with autism. I'm going to pick on autism a lot tonight. That's just because that's an area that tends to get litigated a lot. And that's an example that comes up very frequently. And so we'll have a parent, from a school district perspective, a parent walk in with a medical diagnosis. And that is not enough to qualify a student on its face for special education. We still have to go through an evaluation process with a team of folks who have lots of knowledge about autism. They're going to do a variety of studies or evaluations to make sure there's that educational need component. So someone might have autism but have zero education need, for special education and related services. And so we have to go through the actual process of saying this kiddo qualifies for purposes under the IDEA. Medical diagnosis in and of itself is not good enough. And that same thing comes up frequently with other types of disabilities as well. But autism, it comes up pretty frequently because it's kind of confusing to parents, I think. So I mentioned autism is one of the disabilities that can qualify a student for special education. There are actually 13 different categories under Texas federal law. This is for students between the ages 3 to 21. There are some types of qualifications for really little kiddos. I don't deal with that since my practice is K through 12, pre-K through 12, I guess now. But there are some other things for really young children. But for purposes of public education, students can qualify for their categories of autism, being deaf or hard of hearing, deaf blindness, emotional disturbance, intellectual disability, multiple disabilities, non-categorical early childhood for ages 3 to 5, orthopedic impairment, other health impairment, specific learning disability. That's where dyslexia would qualify under specific learning disability, speech or language impairment, traumatic brain injury, or visual impairment. So other health impairment is the category that gets kind of a, for lack of a better term, a catch-all. There are lots of things that can qualify under other health impairment. The most common one I see is ADHD. That's how students qualify under other health impairment. There are several others, but that's the most common one I run into. So we have to do evaluations. Like I said, they're very prescriptive. There is some flexibility as far as what evaluations you use, but we have a very prescriptive process going through in doing these evaluations. I think the key thing to take away on evaluations, especially if I know we have some people studying to be diagnosticians who are watching, is we have to make sure the evaluation is sufficiently comprehensive to identify all the child's special education and related services needs, whether or not commonly linked to the disability category, in which the child has been classified. So we really are looking for a comprehensive evaluation. It's called the full individual initial evaluation. Full for a reason, because it is comprehensive. And so I always remind folks that it's not a, let's go through and check this one off, and then check this one off, and check this one off. It truly is comprehensive from the get-go. And it really can be helpful to do, or if you suspect different areas, to make sure you're pulling in all those evaluations, so you get a really good picture of the student. And sometimes what they don't qualify for is as telling as what they do. So having that information, like if you're like, well, we're not sure if it's autism or emotional disturbance, or you're looking at a couple different areas, that could be really helpful to look at all those different types of evaluations to get a good picture of the kiddo, so you can draft that very comprehensive and beneficial IEP. So I definitely encourage robust conversations between the school district and the teacher and the parents to really think about all the different types of needs a student might have. So I want to focus now on the actual IEPs. Now we've gone through the evaluation process. We've determined there is a disability, there is an educational need for special education related services. And so we get to the point where we have to develop the actual IEP. Law tells us who has to be in these ARD meetings or IEP team meetings. It's going to be a group of knowledgeable people, just like 504. You're going to have a school administrator who knows about the district resources. You're going to have a teacher of the student or anticipated teacher of the student, a special education teacher, and then there are a variety of other people who might come depending on the disability you're working with. The parents, of course, are critical for being in the ARD meetings. It's very important that parents are active participants and that they definitely need to speak up. And that's something I know I talk to my clients about. If a parent who's quiet, ask them questions because, I mean, obviously they know their child so well. And so we need to have that parent input. It can be, I know I actually went at one time in my career, I helped a family member and I helped them in the Army. I really wasn't there to cause problems. I knew the lawyer for the district. This was many, many, many years ago. But it was really kind of eye-opening to see on the other side, see the parent perspective. And sometimes it's, parents are just kind of overwhelmed with a lot of information. It might be a lot of lingo, all these acronyms that no one knows what they mean. And so I always encourage parents to ask questions, and I encourage educators to slow down and really explain everything because there's a lot going on, especially in an initial ARD. There's so much to take in. And when you get used to doing ARDs, you go to 3 a week or whatever, you kind of forget what it's like to be on the other side. And so I always encourage parents to really stop and ask questions and the educators to try to slow down and go through everything carefully and thoroughly with parents so that they understand the process. TEA actually has a lot of really good material now that's out for parents. There's like a guide to the ARD process. There's just a lot of really good information on TEA's website. So I encourage actually both educators and parents to go read that material. It's a good refresher for educators. It's great information for parents. So when we're looking at an IEP, trying to make sure that we meet the letter of the law as far as the development, the number one thing to focus on at the outset is, again, making sure it's individualized and truly focusing on that evaluation and what recommendations are coming in from the professionals so that we're really focused on that individualization. The law also tells us that students have to be educated in the least restrictive environment, and that is an absolute from the IDEA. We have to make sure that, to the extent appropriate, children with disabilities are educated in the regular ed classroom with the use of supplemental aids and services. And we want to make sure that if we're doing that, we're providing a satisfactory education. So the law doesn't say you have to place students with special needs into the general ed classroom, but that's kind of the default where we start. And we consider that and say, can we provide the student with FAPE in the general ed setting with these additional things that we're offering? If not, then we need to look at a more restrictive environment. But the law does require us to walk through that analysis. Another component of FAPE, looking at IEPs, we want to make sure we have the right stakeholders in the room. And again, I focused on this earlier, making sure parents are there, they're active, they're involved, and really try to make sure that we are working in a coordinated, collaborative manner. And then we're looking for positive academic and non-academic benefits. At the end of the day, when we get, we develop an IEP on September 13th, and we're coming back early September of next year, that's what we're going to be looking for, is those positive academic and non-academic benefits. And so as we're developing goals and objectives, that is the key to what we're really trying to make sure we accomplish. We're looking for that meaningful educational benefit. And we had a case, it was the NDRF case, I think it was in 2017 when that came out. In Texas, the Fifth Circuit has always told us we're looking for that meaningful educational benefit. That's kind of a key term here in Texas. The NDRF case involved a student out of Colorado, and Colorado had for lack of a better description, a lower standard. It was a de minimis kind of standard. And the courts, said de minimis was basically good enough, just a little progress. And in Texas, we always said we want more than just a little. We want meaningful. And so that case, the NRF case, went up to the Supreme Court, who said de minimis was not good enough. And they focused really on a few different things. They want challenging objectives. They want the IEP to be reasonably calculated to ensure a child's making progress. They want the IEP to be appropriate in light of the child's unique circumstances. And we have to have appropriately ambitious goals. And the Supreme Court really talked about how every child truly is different and unique. And we have to make sure we're focused on that, the individualized needs of students. And so that's really what the NDRF case stood for. What I did tell you when I was walking through some of these elements, the individualized, least restrictive environment, key stakeholders, and positive academic and non-academic benefits. That is from a Fifth Circuit case called Michael F. versus Cypress Fairbanks ISD. And I call that one an oldie but a goodie because it's from 1997. So when we got the NDRF case from the Supreme Court, some people tried to say, well, those 4 factors from Michael F. are no longer good. And we've had since the Fifth Circuit come back and say these 2 cases can work together. They're not mutually exclusive. So everything I just read to you is either from Fifth Circuit case law or the Supreme Court case law, that they work together. You can do all those things. And so that is what we have litigation. That's what courts are looking for, are all those factors I just talked to you about. So that's really kind of the key to the IEP. Let me dig into the law a little bit here. As we're developing the IEP, I gotta go faster than sorry, I get long-winded. I'll move a little quicker. As we move into the IEP, the thing I really want to focus on, there's a lot of words up here, they're pretty self-explanatory, but the present levels of academic achievement and functional performance. This is something I would encourage, especially to our diagnosticians or with educators in the room, really focusing on learning how to write a good class. And TEA has some great guidance out there. If you haven't looked through that or learned how to do a class, that's such a key thing. So please take your time in learning that skill. And for parents that might be listening, making sure you walk into the meeting or even send in advance where you see your child performing at home, out in the society, in general, how is your child doing? Because what we do is we look at how is the child doing today? How is he or she doing right now? And where do we want to be in a year? And if you don't have the right now clearly spelled out, how do you figure out what you're going to do and how much progress you'll make in a year? And so that's why that class component is so important. And it's so helpful in really getting a solid IEP. And so that's really what a lot of the guidance out there talks about, is making sure you have great data in that class. And so I'd encourage you to make sure to get some training on writing good class. When developing an IEP, we look at the strengths of the child, the parents' concerns, the most recent evaluation, of course, and then the academic, developmental, and functional needs of the child. And I think sometimes we get hung up on the academics when functional can be just as important. There are some times that, again, the academics are pretty solid, but that functional component is what's so important. Dispute resolution, like I said, here in the Panhandle, we just don't have a ton of litigation. We're very blessed in that way that we can work through a lot of things together. But from time to time, things don't work out. So there are a few different options for parents, frankly, for school districts too, for trying to resolve disputes. The first one I always recommend is if you're in a meeting, it's just not going well, just take a break. Maybe it's just a break for a minute. We all go in the hallway, kind of cool off and try to come back in. and refocus. Or the ARD can recess and reconvene. The law allows for that in Texas. You can reconvene within 10 days if you don't agree on the essential element of the IEP. And sometimes just getting some rest or going back and looking at new information can really help, especially if you've been in the long ARD. When I get in the room with administrators, I always ask, okay, who has the longest ARD meeting record? And some of them have been days, like multiple days. I think 30 hours is the longest ones I heard, over several days. And so when people sit in a room for too many hours together, especially if it's hot or you're hungry or you're tired, sometimes those meetings just don't go well. So sometimes it's a good idea to stop and reconvene. We also have facilitated IEP meetings as an option. Service centers have people who are trained to help facilitate, which is what it sounds like, facilitate a meeting. I've been in a couple of these. They've been really beneficial, I think. The people who are trained to do this are good at navigating difficult conversations. They keep the IEP team on focus. They have agendas, they have guidelines. They really try to guide the committee through some difficult issues. And so I think that can be really beneficial. Mediation, that's a service the TEA offers, and they have mediators who actually that's what they do with special education mediation. Not that a non-special ed mediator couldn't be effective, but it is nice when you walk into a mediation and the person has subject matter knowledge and understands the issues. And so those can be very effective. Parents can also file TEA complaints where they go tell TEA what they think has been done wrong, and TEA investigates it. And then finally, we have a due process hearing option. And that's where parents ask for an administrative hearing in front of a lawyer who's been assigned as a judge. And it's basically, I call it trial on steroids because it moves really fast compared to regular litigation. But that makes sense because you're talking about a child's education. And so you don't want it drag out for years and years, like litigation can be in the outside world. So we try to get those hearings moving along quickly. So there's a kind of different options for dispute resolution. Quick legislative update, and I'll wrap up. Like I said, we just finished, we're now in the third special session, I think it is. And so we had our regular legislative session last year, and I said last school year. And we had several bills that were introduced relating to special education. The theme I saw in the bills that were filed was a lot of it was focused on discipline and behavior. And the vast majority of my just kind of day-to-day calls deal with behavior and discipline because it can be so challenging to try to figure out how to get through the child to figure out what makes us effective because every kid is so different. And now that I have a 3.5-year-old, I have a full appreciation for this topic because it works one day, may not work another. But it is a hot topic, and we did see a lot of bills that were filed. The ones that made it through were House Bill 785, and that addresses 4 different issues. I touched on behavior earlier. We have behavior improvement plans that students might have if we see a lot of behaviors that are unacceptable or violation of student code of conduct. Sometimes we'll create a behavior improvement plan for a child where we look at a lot of times we'll focus on what's the function of that child's behavior. We'll do a functional behavior assessment and say, why is a child doing what they're doing, and how can we respond to help that child in a positive way, get back on track and meet the behavior expectations of the school district. And so we'll have those VIPs, is what we call them, in their acronym. We've also focused on restraints and timeout in this bill, and then we had some new requirements for disciplinary changes in placement. So first, starting with VIPs, and honestly, this is something that I don't think I've been to hundreds of ARDs in my career. I've never seen a VIP not reviewed annually. That's part of the process. So this law, I think, just kind of confirms best practice and what districts are doing anyway. We have to review if there are changes in students' behavior. If there are certain circumstances that might be disciplinary actions for similar behaviors, patterns of unexcused absences, or unauthorized departures from schools. We have to address that in our committee. Again, most districts were doing this very frequently anyway. This is kind of confirming what was best practice. But one thing that non-education folks ask me a lot is, why that excused absence, what's the focus there? And the idea being, and this is hopefully helpful to parents in the room too, if your child's not wanting to go to school, there might be a deeper reason than what appears on the surface. And so it might be they're embarrassed, they're struggling, they're frustrated, whatever the case might be. We all don't want to go to work or school sometimes, but for kiddos who are struggling because of a disability, we might need to look deeper. And so that's what the point of that law change was, in my opinion. We're going to have new rules coming out of the commissioner's office when it comes to restraints. We already have some laws in the books already, so I don't think we're going to see a significant change here. Timeouts, same thing. If a student is put in timeout, there's a full definition for what that means in special education. If a student has a VIP, then we have to make sure that the timeout use, if it's something we plan to do for him recurringly, is specified in the VIP, and there will be certain documentation requirements as well. And we already have some of that, so we'll just be a little more detailed. House Bill, let's see, 785 also talked about functional behavior assessments and behavior improvement plans, in the sense that now, if we have a student who has a change of placement, which generally means 10 days of removal to a disciplinary setting, or a pattern of removals that results in a change of placement, and that's counting to 10 is really difficult in school. And it's just because there's lots of different caveats along the way, and figuring out what a change of placement can be very complicated. But generally speaking, if you're seeing a significant change in a student's placement due to behavior, there's some things we have to do now. Again, lots of people were doing this, districts were doing this already as best practice, but now the law says that not later than the 10th day after the change of placement, school district has to seek consent of the parent to do a functional behavior assessment and review, unless there's one on the books already that was less than a year old, you have to get permission to do it, or you have to ask for permission to do an FBA. And then you have to review any BIP that might be in place. So again, this gets a little bit in the weeds, but if there is a change in behavior, change in placement for a student, we have to have what's called manifestation determination for discipline purposes. And so we're getting together as an ARM committee and talking about the discipline situation. So now the legislature is making sure that we're talking to parents about dysfunctional behavior assessments. And the idea behind it being, if we're seeing behaviors, we need to understand the why, and then make sure we have a plan to address the behavior. So that's a pretty significant change in the law. Like I said, a lot of districts were doing this as a matter of practice anyway, but now it's required. So it's really different. And then as necessary, once we get that FBA done, if we get consent as a school district, we need to develop a BIP, or if they have a BIP, revise that BIP. We could be here for about 10 hours talking about the next bill, which is House Bill 4545. I'm not going to go into that much detail because it's just so complicated. The last FAQ that I printed off of TEA last week was 32 pages on how to implement this law. So it's significant. I won't read all this to you, but the gist of it is, if a student did not pass the STAR in grades 3, 5, or 8 in math or reading, school districts now have to provide accelerated instruction. And it's 30 hours of accelerated instruction for each area the student didn't pass. And so it's significant, very significant. There are requirements for the ratio of students to teacher, when you can do it, like you can't pull kids out of recess, it is in certain classes. There's very stringent guidelines for the school, or requirements, I should say, guidelines, requirements for school districts to make sure they get this accelerated instruction done. This is actually from a TEA handout. They put together some pretty nice handouts that try to break down this law. The hot topic on this is parents wanting to opt out because they don't feel like their child needs 30 hours of accelerated instruction on something that happened, frankly, during COVID. And there's a lot of frustration out there. What TEA is telling us is that this is a requirement. It's a compulsory attendance issue. And basically that parents they can't just opt their child out of it. We've seen some creative ideas come through from parents, but frankly, it's just TEA is saying that's not really an option. An update that came out on September 2nd, because there was a lot of questions from schools saying, but what about special ed students? Aren't we supposed to be individualized? And TEA came back and said, well, the ARD committee can reduce or modify accelerated instruction, but there has to be some reason related to a faith that you're doing that. And so again, this will take really individualized analyses to try to figure out if that student needs the accelerated instruction or if it contradicts their right to a faith. And so those are very detailed types of analyses. So I went a little over, but I think I still have time for questions. So do you have some questions? So like the TEA resources and that kind of thing, or okay, for actual cases. Sometimes TEA or the regional service centers, if we're in Region 16, Region 18, Region 20, they've got a lot of resources. Sometimes they'll cite case law. There's a lot of material on the internet. I would just say that if you're looking at that kind of material, I would be focused on finding a Texas law firm that put out the material. If you're not finding what you're looking for with the service centers or TEA, most of the guidance, I'm trying to think, most of the guidance I see out of the agency doesn't have a lot of references to cases. So probably your best bet would be to research online for legal articles on point and making sure that they are Texas specific. And then when you're looking at case law, the Fifth Circuit is what applies to Texas, and then the Supreme Court, of course. And so if you're looking at resources that talk about the Third Circuit or the 10th Circuit, that might be instructional, but it's not binding in Texas. So whatever resources you might come across, I wish I could point you to a really solid one. Jim Walsh from our firm wrote a book, but it's not just about special ed. There is a chapter there about special ed. I think there are a lot of books out there as well that have references to case law. But again, if it's not Texas specific, it might have misleading information in the sense that it's not binding. Does that help you? Okay. Yes. Okay. Yeah, the question was that about 45 are their best practices for basically implementing those 30 hours of accelerated instruction. I would say that is a question for an educator. I know. And I would say, truly we might be, we're involved at the high level of looking at the legalities of can you opt out or can you modify. But as far as actually best practices for doing it, I really couldn't answer that because it's so new. I know a lot of districts started working on it the minute they got back to school. And so I know what some of my clients are doing that I think sound really great on how to make that work. But I think it's going to vary a lot from district to district. And I think it might be different, large district versus a small one, trying to figure out your scheduling and that kind of thing. So I would say, no, I personally do not know what might be a best practice. I think everyone's trying to figure this out as we implement this law on day one. They really had not enough time to plan, but districts work so hard to get ready for it. I think it's kind of evolving. TEA is saying they're not going to, they expect districts to follow the law, but they're not going to, the words of TEA's mouth. But basically, they don't plan to be real harsh the first year as we're trying to figure out how to implement these requirements. But they certainly don't want school districts to be willfully not complying. So I think we'll see more and more best practices coming out of the first few months of figuring out how to do this. So I wish I could answer that better. Sorry. I know. That's the $1 million question for sure.
And then we have areas special education and ITPA. So this parents where I can think, so how do we know that she's any advice?
That's a great question. And so the question was in the decision tree basically for dyslexia, do you do 504 or IDEA? I would encourage parents and school districts to talk about the actual evaluation that comes back for that child to try to figure out the best way to serve the student. And frankly, without seeing the new updated handbook, I'm not sure what exactly the guidance is going to say on that. But I've been in a few R's where we've talked about, do we think the more programmed approach to dyslexia, the state approach to it, or 504 we think really would work because it's such intensive approaches to helping that child learn, and versus maybe having to add in a few other things that's beyond just kind of the prescribed type of approach. So I'd encourage parents to ask the district, what does it look like if we do option A versus option B, and ask for specific examples as to what the difference might be. But again, I'm really anxious to see the new handbook to figure out what TEA has come up with, because I'm kind of speculating at this point. But for as far as to craft the guidance for both schools and parents, it's just to really look at those evaluations to see what the child needs specifically, and if the designated curriculum appears to meet the child's needs. If not, they probably need to be in special ed.
Saying that
good.
Collective days or
Yeah.
And so the question is and that could apply to or any evaluation. What advice do you provide?
So the question is, what if you're trying to get consent from a parent, whether it's through for the functional behavior assessment under Community House Bill 785 or just in general? And I think that just truly, if parents are hesitant to give consent, helping parents understand what that evaluation looks like goes a long ways. And some of the best directors and administrators I've seen over the years, really just go through that point by point and say, here's the test that we're looking at doing. Here's what will tell us. Here's what it looks like, generally speaking. Because when you hear as a parent, we're going to do this testing, you don't know what it really means unless either you read a notice or whatever. Sometimes if you're not familiar with those terms, it can be kind of confusing. And I think so it's really important for parents and somebody in the district, whether it's a diagnostician or the licensed specialist in school psychology or the director, to really go through that together. And so for school districts, if a parent says, I don't want to give consent, ask why. Because I think the why behind it a lot of times will help get that parent to understand why the school wants to do it, what it looks like, and just talking. And I've seen where parents are withholding consent until they actually are explained in lots of detail. And sometimes those conversations take a while. And for parents, ask the why, the how, the what's it look like, so you know exactly what's going on. I think a lot of times that helps. What's interesting though, this isn't quite what you asked, but I think it's going to come up on House Bill 785, it says we have to this district has to seek consent for that functional behavior assessment. That includes for students, for example, who maybe have a learning disability and are caught selling drugs. So, when we look at diving deeper, is there a link between the behavior and the disability? And so even in those situations where there appears to be no real connection there, we still have to seek consent. And so, because the law says that there's going to be a change of placement. And so I anticipate some parents saying, we don't really need to look at the function of behavior of selling drugs, and they may just not want to give consent. But I think, as districts, you make the parents aware of what's available and what that might look like. The parents ultimately, that's their choice. Sure. That's just state, that's Texas specific. And so that goes in, I think I have it in there. It's under Chapter 37 of the Education Code. And so Chapter 37 of Texas law, the Texas Education Code, that deals with all student discipline. So that's not just special education specific. That whole chapter deals with all discipline of students. So if you're looking at, and sending this child to DAP, which is a disciplinary alternative educational setting, or you're expelling a child, all of that's in Chapter 37. That's a great question. The IDEA has not been updated for a really long time, and we keep thinking it's going to happen, and it just doesn't. 2004 was the last major overhaul of the IDEA. And so I'm not positive on state-specific legislation. I can tell you, just from going to national conferences, behavior and discipline is always a hot topic. So I wouldn't be surprised if other states are doing things similar. I just am not aware of it personally. But behavior and discipline is always a challenge.
Well, thank you, Andrea. We really appreciate all the information that you gave us. And just kind of a side note from a parent, to all of you who are education, in the education services, and for those who are pre-service teachers, the one thing from a parent standpoint that will get you further than anything else, if you will listen. Listen to those parents, because when they're going to get really frustrated when they're in the middle of an ARD and they don't feel like that they're being heard. So that's the best advice that I can give you from the other side of the table. So we want to thank you, and thank you so much, Andrea. This is great information. And thank you for those of you who are out there on Zoom and those who came tonight. We really appreciate you, and we hope that you are able to take this information and help those students who are out there. We are all on the same team.